All right, let's be on the record in case number 2020CR579, captioned State of Kansas versus Stephen D. Phillips. Will the parties announce their appearances, please?
May it please the court, the state of Kansas appears by Assistant District Attorney Kayla Rayler. Marcus, you're on mute.
May it please the court, Stephen Phillips appears in custody and by counsel Mark McLaughlin via Zoom.
All right, we are here set down for a plea. Before we came on the record, the parties advised the court that the intent is for the defendant to plead guilty to count 2 of the original information, charging him with criminal damage to property, a Class B non-person misdemeanor, and that the parties are going to recommend that the court sentence Mr. Phillips to time served, but also assess the court costs and restitution against Mr. Phillips, that both parties are wanting to waive PSI and proceed to sentencing today. Mr. McLaughlin, do I have that correct?
Yes, Your Honor.
Ms. Rayler, you agree?
Yes, Your Honor.
All right. And obviously, that if I'm given time served and closing the case today, I'm going to be referring all of those payments owed by the defendant to collections. My understanding is the state is objecting to that. Is that correct, Ms. Rayler?
Yes, Your Honor.
Okay. All right. So, Mr. Phillips, to take up this plea, I need to ask you a bunch of questions. All right. If I ask you something you don't understand, you tell me that, and you and I will talk until you do understand it. If at any time you want to talk to Mr. McLaughlin in private, I have the ability to send you there before you answer one of my questions. So if you need to do that, you just tell me and I'll let you do it, okay?
Yes, sir.
All right. Now, I don't mind you keeping that mask on. In fact, I think it's a good thing, but it does make it a little hard to hear. So if you would speak up really loud so my court reporter can hear everything you have to say.
Yes, sir.
To start, we need to have you sworn in. So if you'd raise your right hand, she'll swear you
in. You solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you.
Go ahead and put your hand down. All right. Mr. Phillips, as you sit here today, you feel like your mind is clear?
Yes, sir.
All right. Are you under the influence of any alcohol, drugs, or prescription medicine that might keep you from understanding what's going on?
No, sir, I'm not.
Okay. Do you know what you're charged with?
Yes, sir.
You know you don't have to change your plea from not guilty to guilty if you didn't want to. And if that was the case, you would have a right to a jury trial on these charges. You understand that?
Yes, sir, I understand.
All right. The state would have to put on enough evidence at that trial to prove you guilty beyond a reasonable doubt. You wouldn't have to prove anything yourself. Mr. McLaughlin would help you throughout that case. He would get to cross-examine all the state's witnesses, challenge their evidence. He could call any witnesses you wanted called. You could testify at that trial, or you could decide not to testify at that trial. And if you decided not to testify, it couldn't be used against you. In other words, the state couldn't argue you must be guilty because you didn't take the stand. Do you understand all that?
Yes, sir, I understand.
So if we went through that whole thing, and at the end of that trial you were convicted, you would be able to appeal that conviction to the appellate courts. And if you didn't have the money to do that, a lawyer would be appointed to do it for you. Do you understand that?
Yes, sir.
All right. Any questions about any of those rights and what goes on in a trial?
I don't know if I'm allowed to ask this, but what I'm trying to figure out is so as far as today, like if I pled no contest and for the Class B misdemeanor, would is it not, it's going time served and then it's restitution. It's not putting me out on the streets on probation, right?
The request and the recommendation for sentencing is that you be given time served and not placed upon probation.
Yes, sir. I'd be much more comfortable with that. And like I said, I understand everything, but yes, sir, that would be great for me.
All right. Do you have any questions about anything that we talked about?
No, sir, I don't.
Mr. McLaughlin, know any reason? Oh, I guess I should tell you, this thing that you're intending to plead to that we talked about a second ago, it's a Class B misdemeanor, which means it carries up to 6 months in jail and up to a fine of $1,000. Do you understand that's the maximum for that case?
Yes, sir.
All right. Mr. McLaughlin, know any legal reason why I should not now proceed, or why your client should not plead?
No, Your Honor.
All right. Then I'm going to ask you, Mr. Phillips, as to count 2 of the original information, charging you with criminal damage to property, a Class B misdemeanor. How do you plead? Guilty, not guilty, or no contest?
No contest.
All right. Ms. Rayler, if you had to put on a trial, what do you believe your evidence would be?
Your Honor, if this case proceeded to trial, the state would present evidence that on or about the 21st day of August 2020, officers responded to 3444 North 59th Street in Wyandotte County. When they arrived, they would speak to Tiffany Harding and Linda Cook about what happened. They would indicate that the defendant, Stephen Phillips, had broke down the door of that residence. The state would speak with Mr. Phillips that day. I apologize. They attempted to speak with Mr. Phillips, who was found down the street carrying items consistent with what the victims relayed happened. He would not give a statement to police. The state would present evidence that these events occurred in Wyandotte County.
All right. Mr. Phillips, you understand I'm not asking you if you agree or disagree, but you understand that that's what the state believes they could put on for evidence.
Yes, sir.
All right. I am going to find that the defendant has freely, voluntarily, and intelligently entered into his plea of no contest. He understands the nature of the charges and the consequences of the plea. The state has provided a sufficient factual basis for a finding of guilt, and I will in fact find that he is guilty of count 2, criminal damage to property, a Class B misdemeanor. Per the plea agreement, the other counts in the information are dismissed. Parties are waiving a pre-sentence investigation, so I would hear any comments, Ms. Rayler, as to sentencing.
Your Honor, the state would ask that this court follow the plea agreement in this particular case and sentence the defendant to time served. The state would ask that the court order $350 in restitution. It's a little complicated because Crime Victims Comp haven't decided whether they're going to pay out that money to the victim or not. So I would ask that it be ordered as an or, Crime Victims Comp, or to Linda Cook or Tiffany Harding, based on whether or not Crime Victims Comp pays the victims in this particular case. The victim provided that $40 to $60 had been taken during the course of the events. She says it was cash. Was not able to provide supporting documentation. When I look at the Crime Victim Comp application, she does not indicate the amount of her source of income. She says she's on Social Security, but does not provide her actual income for her Social Security, the monthly amount. So whatever the court deems appropriate for any money that may have been taken. I will note for the record, in reviewing the police reports, the defendant was found shortly after the call had been made. They found cigarettes, which are alleged to have been taken, and a lighter in his pocket, but they did not find any money on his person.
All right. Mr. McLaughlin, comments.
Your Honor, we would just ask that the court abide by the plea agreement. I believe as far as the first part of the restitution, we have no problem. As far as any cash, I'm thinking Mr. Phillips wouldn't have any problem as far as this estimate of possibly the cigarettes and any other items he actually had on his person, as far as any additional money.
All right. I would ask you, Mr. McLaughlin, are you appointed in this case?
I am appointed.
All right. Do you have any idea what your attorney fees are going to be?
I haven't added it up yet. I mean, I'm thinking it's going to be roughly $600.
Okay. All right. Mr. Phillips, now's your opportunity to tell me anything you want me to know before I proceed with sentencing today.
I don't have anything, Your Honor.
All right. So here's what I'm going to do. I don't know that I can um, assess against the defendant an unknown amount of cash, particularly when he was caught quickly thereafter and did not have that on him. So I am going to assess the $350. That either goes to the victims, or actually I'm going to order it to the victims, and then they can deal with crime victims comp. Obviously, they have to sign documentation with crime victims comp that says if they've been paid otherwise, that they are to allow them to let them know. So if crime victims comp pays the victims before the restitution is received, then that restitution should be directed to crime victims comp, and they should let the clerk know that when they have that, for lack of a better term, lien. And the victims are under an obligation, if they receive the money from the defendant, to let crime victims comp know and return any money that is double payment for that to crime victims comp. I'm going to assess $100 of Mr. McLaughlin's fees, as well as court costs. In this case, there is no supervision fee, given that he's not going to be on supervision, and it's not a felony, so there's no database fees. So it's going to be $100 for Mr. McLaughlin's fees, $350 to the victims, and then remind me on misdemeanor costs, $122.50 or something like that, I think.
Judge, I can never keep the costs straight.
Give me 1 second. It is $158 even. All right.
So did they change it so it's the same as a felony level now?
Well, I think it isn't felony now 193. I don't know. I was just looking out an old cost sheet.
I can never keep it straight. I'll just mark court costs on the journal entry and the clerks can figure it out.
Okay. All right. So the defendant will be sentenced to time served. This case, since he's not being placed on supervision, this case is going to get closed upon filing of the journal entry. These amounts are going to be well, I'm wondering, here's the deal. Here's what I'm going to do. I'm going to leave it open for 30 days for payments to be made. At the end of 30 days, he's not going to be on supervision. At the end of 30 days, the case will be closed. Whatever's not been paid will be referred to collections. That way, the defendant has a top contact point to make some payments. Because if it just goes to collections, I don't know how they end up getting a hold of him. So I'm going to leave it open for 30 days. Mr. Phillips, here's what I want you to do. When you get out, give it a few days, because we're going to have to get the journal entry over to the clerk. But sometime in the next 30 days, show up at the clerk's office to find out what your total amount that you owe is. And if you can pay it off before 30 days comes along, and as I look at it, it's going to be somewhere in the neighborhood of $600. That's just kind of a rough, maybe $500. If you can pay that off in the next 30 days, you will avoid all the fees that go along with it going to collections, okay? And this case can truly be behind you. Otherwise, they're going to refer the the rest to collections. And then whoever the lawyer is who collects adds their little fee on top of it and all of that. So it ends up costing you more, okay?
Yes,
All
sir.
right. All right. Anything I haven't covered today, Ms. Ray?
Judge, just so we're clear, the total underlying time for the defendant's sentence would be 143 days. That would be August the 21st to today's date.
Sounds like it to me, Mr. McLaughlin.
And then if the court would allow to give me just a second, I can share the screen and have Mr. McLaughlin review the journal entry right now, and we can get it filed in 10 minutes.
Sounds good. But Mr. McLaughlin, anything else to add?
No, Your Honor.
Okay, then I'm gonna go off the record and let Amanda go, and then we can do this thusly.
Thank you.
Okay? All right, we're adjourned. Thank you, Amanda. See you at 2. The 1 o'clock's gone. Yep. All right.
And then, Judge, do you want to stop streaming?